The provincial government wants the Supreme Court of Canada to hear its appeal of a lower court ruling on Saskatchewan's school pronoun law. The province is seeking leave to appeal, basically asking the Supreme Court to hear its case. It also wants the court to expedite the appeal application because the case is of national importance. The province argues the case raises questions about the court's jurisdiction when the notwithstanding clause is invoked. Premier Scott Moe's Saskatchewan party government introduced the pronoun policy in 2023. By law, schools must get parental consent for students under 16 before using their chosen name or pronoun. The University of Regina Pride Centre challenged the policy in court. It argued the policy violates the Charter of Rights and Freedoms and puts 2S LGBTQ+ students at risk of harm. In response, the province invoked the notwithstanding clause. This rarely used measure lets governments override certain charter rights for 5 years. In 2024, the court ruled in favor of U of R Pride and denied the province's request to toss the case. The government appealed. In August, the Saskatchewan Court of Appeal ruled the U of R Pride challenge can continue. Now the two sides are preparing for a possible hearing at the Supreme Court. The province wants the Supreme Court to hear the case alongside a challenge of Quebec's religious symbol laws. The Quebec government invoked the notwithstanding clause when it passed a law preventing public sector workers from wearing religious symbols on the job.
So you have this clash over federalism happening at the same time that the provinces are seeing they're losing at the Supreme Court of Canada. And so the province's new logic is, well, we got to use the notwithstanding clause to win. We can't just rely on thinking the courts are going to be fair to us anymore. And that has put pressure on them to do this.
The Supreme Court has not yet decided if it will hear Saskatchewan's appeal. Jeremy Warren, CBC News, Saskatoon.